The House will come to order. The pledge today will be led by Caitlin Cameron, Lauren Wilson, Matt Miller, Abigail Groth-Lucien from Classic Academic School, Colorado Springs, Colorado.
Please join us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
You can just get to
Bless you.
So pathetic. If anyone asks, my name is Piper. Nice to meet you.
Mr. Kohler, please call the roll.
Representatives Arndt, Becker J, Becker K, Brown, Buck, Buckner, Carver, Conti. Quorum is present. Court, Danielson, Del Grosso excused, Dorr, Duran, Esgar, Everett, Fields, Foote, Garnett, Janal, Hamner, Humphrey, Joshi, Kagan, Representative Kagan, Kaiser, Klingenschmidt, Kraft-Tharp, Landgraf, Lawrence, Lebsock, Lee, Lontine, Lundin, McCann, Melton, Mitch Bush, Moreno, Navarro, Neville, Nordberg, Pabon, Pedersen, Primavera, Priola, Rankin, Ransom, Rosenthal, Rosenthal, Rupe, Ryden, Sane, Salazar, Sias, Singer, Tate, Thurlow, Tyler, Van Winkle, Representative Van Winkle, Van Winkle? I haven't heard anything. Okay. Van Winkle excused. Vigil. Willett. Williams. Wilson. Representative Wilson. Windholes. Winter. Young. Madam Speaker.
With 63 present and 2 absent, a quorum is present. Two, I beg your pardon. 2 excused, they are not absent. A quorum is present, and Representative, who is it? Lundin or Tate? Tate, Representative Tate.
Thank you, Madam Speaker. I move that the reading of the Journal of Thursday, April 9th, 2015 be dispensed with and that it be approved as corrected by the Chief Clerk.
You have heard the motion that the journal be adopted as corrected by the Chief Clerk. All in favor say aye. Good. That was a good strong aye. All opposed say no. That was a very weak no. The ayes have it. Motion passes. Announcements and introductions. Representative Lundin. See it. Is this?
Thank you, Madam Speaker. Ladies and gentlemen, members of the House, we are joined today.
Representative Lundin, would you give me 2 minutes to get this boisterous crowd under control?
Madam Speaker, I'm willing to give you as much time as you would like.
So I did get a little silence. Would we have more? Please take your side conversations outside, and please give Representative Lundin some respect here. Thank you.
Thank you. Ladies and gentlemen, members of the House, we have today joining us 38 members of the Classical Academy, also known as TCA. It is the largest K-12 charter school in Colorado. Launched in 1997 with 400 students, TCA currently has 3,700 students across 3 campuses in 7 programs. They are led by teacher Bob Frick, and their mission, listen to this, ladies and gentlemen, the Classical Academy exists to assist parents in their mission to develop exemplary citizens equipped with analytical thinking skills, virtuous character, and a passion for learning, all built upon the solid foundation of knowledge. However, the most important thing I'll say from this podium at this time is I am working hard to win the Best Uncle Award, and I'm going to risk a fine to say my nephew was part of the group that helped lead the pledge, and his name is Matthew Miller. Please welcome the folks from TCA.
That's perfectly fine, Representative Lundin. You can introduce your relatives anytime. Representative Salazar.
Thank you, Madam Speaker. I sought permission from the Majority Leader, the Minority Leader, and yourself to be excused from 1 o'clock to 4 o'clock today in order to close on a house, and so I asked for permission to be excused during that time period.
Congratulations. Representative Salazar is excused at the time requested. Representative Jay Becker.
Thank you, Madam Speaker. And members, many of you may know or may not know that this week is National Auctioneers Week. And the mission of this group is to make sure you spend your money at these auctions wisely, if you've ever met these folks. So I'll tell you, I'd like to introduce the group, the Colorado Auctioneers Association. You may have noticed all the cowboy hats running around the Capitol today. There's 12 of them sitting against the wall over here. Please welcome them to the Capitol. And Madam Speaker, if I might, I want to be a good nephew, so one thing that I want to introduce here is my uncle is sitting over there, happens to be the president of the Colorado Auctioneers Association, O.J. Pratt, if you'd stand up right there. And my cousin, my long-lost cousin, happens to be the chair of that, Mr. John Schaffner, sitting over there as well. And I have to tell you, my brother is over there. Butch Hagelstrom is sitting over there as the vice chair of this great group, and if you'd welcome them all as well.
Thank you very much, Representative Jay Becker, and that's only a $2 fine. Representative Williams.
Thank you, Madam Speaker. And members, it's opening day at the Rockies. Yeah. We're opening up with the Cubs. So if you are wearing jeans today, if you have on your favorite Rockies jersey or your T-shirt or a sweatshirt, I'll be coming around to collect your $5, and we'll see how much we've raised for the Speaker's kitty. Thank you, and go Rockies.
Representative Janal. And Representative Young.
Thank you, Madam Speaker, and I would like to welcome Clubhouse Colorado today. They're sitting in the left-hand corner up there. Wave, give a wave, Clubhouse Colorado. What Clubhouse Colorado does is they are a model of rehabilitation for a lot of folks with disabilities, And they are a community of individuals that are committed to achieving vocational, wellness, social, and financial goals in order to contribute to society while living independent, fulfilling lives. And I urge all of you members to go and say hello to them. They are not only sitting on the floor today in the far left, but also they will be outside the old Supreme Court chambers till 9:30. So please say hello to the Clubhouse Colorado, Spirit Crossing from Fort Collins, and
Yes, I'll just go ahead. Thank you, Madam Speaker.
Representative Young, please
Thank you, Madam
proceed.
Speaker. And I also want to give a shout out to the folks from Greeley from the Frontier House who are also over here on the far left. And folks, they just celebrated their 25th anniversary on April 1st. This is a phenomenal program that really provides much needed services, and we're so happy to have them as part of our Greeley community. Thank you.
please give them a warm welcome.
Are there further announcements and introductions? Further announcements and introductions. Representative Pabon, Mr. Speaker Pro Tem. And it looks like, in addition to that, Madam Assistant Minority Leader. Now, this is a very serious moment, folks, so we expect your undivided attention. So, Mr. Speaker Pro Tem, Madam Assistant Minority Leader et al., please proceed.
Thank you, Madam Speaker. And members, this is a very important moment in the history of the Colorado House of Representatives. So it's important that we have your attention this morning. Members, what we just paraded down the aisle of the Colorado House of Representatives was an award that was given to the House of Representatives for winning the inaugural Hop the Vote challenge against our Senate colleagues. And so we are going to, yes. Representative Lawrence and I are now going to regale you in the win and what's next for the Hop the Vote challenge. So Representative Lawrence.
Well, as Speaker Pro Tem Pabon had just mentioned, this was a very important competition between the House and the Senate. And I think, for the most part, Coloradans and especially people in this chamber forget that it's not always about Republicans versus Democrats. The real battle is House versus Senate.
Yes.
And again, let's just reemphasize, we won.
Yes.
So as we get ready for the next team challenge, because there will be another one for the Great American Beer Fest, we are recruiting anyone in this chamber who would like to participate in what is a really fun activity. You get to work at a local brewery and we brew our own beer. We go through the whole process, and then we all get to take turns and serve at the Great American Beer Fest. And that's when your campaign skills really come into play. Because you have to get people who are walking by the booth to step over, try the 2 beers, and you have to use your skills of persuasion to get them to vote for the house brew. So it's actually work, but it's really a lot of fun.
Representative Pabon, Mr. Speaker Pro Tem.
Thank you, Madam Speaker. And for those of you who have not yet experienced this or don't know what we're talking about, let us just explain. Hop the Vote is the bicameral, bipartisan, and mostly friendly competition to see whether the House or Senate can brew the best small batch craft beer and let the voters decide. Those are the attendees of the Great American Beer Fest. At the 2014 festival, the House of Representatives brew, which was called Representative Saison, the opposition candidate, edged out edged out the Senate's upper chamber fresh hop pale ale, and listen to this, on a 52% to 48% vote of all GABF attendees. This competition not only received widespread press coverage, but it really helped engender relationships across both sides of the aisle here in the House. And so we never do this alone and want to recognize our members who are in the chamber and here in the well with us who participated, Representative Singer, Representative Williams, Representative Janal, Representative McCann.
And from the Republican side, we have Representatives Van Winkle, Ransom, Rankin, and Neville.
But we're looking for more team members this next year because we understand that the Senate is pretty upset. In fact, here's what happened last year. Representative Holbert was co-captain of this team, and after losing, we banished him to the Senate. So we don't want any of us to suffer that same fate. The bottom line is, look, we see and we hear the superiority of the House, and now we can taste it in Representative Cezanne. We don't have any samples, as I've heard many times from this chamber, even though it's 9:30 in the morning. It's been budget week, but we do have some opportunity to sample some more craft beer at our team meeting, and I hope all of you got this on your desk. Wednesday, April 22nd at 5 p.m. at the Lost Highway Brewing Company for our second annual meeting. But before we get there, we could not have done any of this without our close friends and partners, the Denver Beer Company, and the owners and co-founders of the Denver Beer Company, Patrick Crawford and Charlie, and Steve's also here from the Brewers Guild. So let's give them all a round of applause. And of course, last but not least, one of the benefits of participating in this is your attendance at the Great American Beer Festival, September 24th through 26th, to help, again, pour and sell this beer. And so now we're going to present this trophy, this award, and you can come see it in the speaker's office or on the speaker's dais this morning. On behalf of the team who participated in this, to the Speaker of the House, as award winners of the inaugural Hop the Vote Challenge.
You're very welcome.
And where do I put
I
this?
have no idea.
Maybe we can set it. Maybe we can set it over here.
Okay, we can do that. They want to take some photos. They want
So,
to take some photos.
they want to take some photos. Okay, here we go.
There you go. We started our day off on a high note.
Oh, yes, indeed. I'll let you set that right there. So thank you very much, Mr. Speaker Pro Tem and Madam Assistant Minority Leader et al. I am deeply honored and privileged to accept this wonderful trophy on behalf of the House of Representatives, and I plan to place it in a place of honor in my office between my McGovern hat and my resolution to abolish the Senate. So thank you very much. Now, are there further announcements and introductions? Representative Ryden.
Thank you, Madam Speaker. A really hard act to follow, but members, it's time for another senior moment. Earlier this week, you should have received a flyer on your desk. These flyers come to us courtesy of the Area Agencies on Aging. And on the back of each flyer is a map that shows you your district and where your center is. This week's message was about nutrition, and I guess I've heard that beer is a food. I don't know if it's on the list of nutrition for our seniors, but anyway, you will find some stories of folks that live in your district and how the services that we've been able to provide help people stay in their homes longer. And that is our big objective.
Representative Ryden, let me get a little more order here, if you don't mind. I know you're having great conversations, but please place your attention to the well. Thank you. Please proceed.
Thank you, Madam
Representative
Speaker.
Ryden.
And members, I know you're really excited about the beer festival, and I don't blame you. But let's just take a minute to think about the great senior services that we have been able to provide. Think about the future silver tsunami that's coming and how we're going to cope. And pretty much all of us will be there, I guess, if we're lucky. So thank you so much for listening and for looking at the flyer and hearing the stories about the seniors that are in your districts. Thank you.
Representative Singer.
Thank you, Madam Speaker. And I know we've had a lot of fun hopping to it, but we also distill some great ideas here in the state of Colorado. And the Colorado Distillers Guild would like to invite you, along with the Colorado Tourism Office, to the first annual legislative tasting of Colorado craft distilled spirits, Wednesday, April 15th, 5 to 7 p.m. at the Governor's Mansion. So feel free to join us. Let myself know. Representative Nordberg will be helping out, as well as Representative Pabon. And like I said, it's a growing industry. Let's support something that's going to bring tourist dollars in and raise all our spirits.
Are there further announcements and introductions? Seeing none, the next order of business is second reading of bills. General orders. Representative Lee. You have heard the motion. It's a proper motion. If there are no objections, Representative Lee will take the chair.
Come to order. With your unanimous consent, bills will be read by title unless there is a request for a reading of a bill at length. Committee amendments will not be read unless requested, as they are printed and in your bill folders. Floor amendments will be shown on the screen and not read unless requested. Bills will be laid over upon the motion of the majority leader, and the coat rule is relaxed. Mr. Kohler, please read the title of House Bill 1307.
House Bill 1307, Representative Esgar, also Senator Stebbins, concerning modification of the definition of the term qualified commercial structure as the term is used in the Colorado Job Creation and Main Street Revitalization Act.
Representative Esgar.
Thank you, Mr. Chair. I move House Bill 1307 and the committee report of the Business Affairs and Labor Committee.
To the committee report.
Thank you, Mr. Chair. The committee report simply amended the bill to change an and to an or. It was very contentious.
Is there any discussion of the committee report?
Seeing none, all in favor of the committee report, please signify by saying aye.
Aye.
Opposed? The committee report is adopted. Representative Escar to the bill.
Thank you, Mr. Chair. Members, this bill is simply a cleanup bill from a drafting error from a bill that happened last year, the Colorado Job Creation and Main Street Revitalization Act that passed last year. As OEDIT and DOR and the Office of Archaeology and Historical Preservation were starting to implement this program, there was a discrepancy in the definition of what a qualified commercial structure was with what the federal definition is. This bill simply makes them match. I ask for a yes vote.
Is there any further discussion on House Bill 1307? Seeing none, all in favor of House Bill 1307, please signify by saying aye. Opposed? The ayes have it. House Bill 1307 is adopted. Madam Majority Leader.
Thank you, Mr. Chair. I move to lay over Senate Bill 137 until Monday, April 13th.
Seeing no objection, Senate Bill 137 will be laid over at the request of the Majority Leader. Mr. Kohler, please read the title of Senate Bill 197.
Senate Bill 197 by Senators Crowder and John, also Representatives Fields and Willett, concerning the prescriptive authority of advanced practice nurses.
Representative Fields.
Mr. Chair, I move Senate Bill 197 if there is no committee report.
To the bill.
Members, Senate Bill 197 is a workforce development bill. It's about quality, it's about access, it's about cost. Basically, what this bill does, it reduces the requirements for advanced nurses to be able to have prescriptive authority with a 1,000-hour limit. I urge and I vote.
Representative Willett.
Thank you, Mr. Chair. You know, what we have going on is a brain drain and a talent drain. These prescriptive nurse practitioners are leaving Colorado to go to other states where there's less hours. So we educate them here, we invest all our time, effort, and money, and they're going elsewhere. I have that problem in my district on the West Slope with a great nursing program at CMU, so this is good for rural Colorado as well as urban areas. And I urge and I vote.
Representative Joshi.
Thank you, Mr. Chair, and members, I would like to thank our sponsors for this bill. As you just heard, that we definitely have a significant deficit in medical providers, and this bill will help to get our patients, particularly in the rural areas in primary care, a lot of help. There were some issues when the bill came out, and all stakeholders got together, they resolved it, and at this point it looks really good. It passed unanimously in the committee too. So I also support this bill, and I thank the sponsors again.
Representative Mitz Bush.
Thank you, Mr. Chair. Colleagues, I rise in strong support of this bill. As others have said, this is very important for rural Colorado. I have two small colleges in my neck of the woods, Northwest Colorado, which have just started nursing programs. It would be indeed a shame, as we heard from Representative Willett, if the nurses trained there then went to our neighboring states. And moreover, we really need these primary practice people in rural Colorado. Thank you.
Representative Ransom.
Thank you, Mr. Chair. We sat and listened to a lot of nurses in the Health Committee come up and talk about how the current number of hours, 3,600, is just overkill. And we had doctors come in saying that they didn't have time to spend with these nurses when people that are already nurses can train them absolutely adequately. This is a great bill. I hope everybody will support it. It was it's not good just for rural Colorado, it's good for all of Colorado, because our current requirement is just complete overkill. Thank you.
Representative Corum.
Thank you, Mr. Chairman. Members, I became a little concerned this morning when I saw the procession coming down the aisle. I thought it might be Representative Del Grosso's ashes, but thank God it was an award, so thank for that. But this is a great bill. It's a good bill for rural Colorado. In rural Colorado, as they call it, rural, remote, it may be 100 miles to the nearest doctor. In the the small community of Dove Creek, the only medical attention they've had there for the last 35, 40 years has been a nurse practitioner. Now, I think it's unfortunate that we have great programs graduating great students, and then 70% of them move out of state for employment. So this is a great bill. Thank you.
Representative Escar.
Thank you, Mr. Chair, and I stand in support of this bill as well. This is good for rural Colorado, but this is also good for all of Colorado. These are good-paying jobs that we're giving away to neighboring states. We need to figure out how to keep these advanced nurse practitioners here that want to stay here. They just haven't had they feel like they're up against a wall when it comes to the amount of hours we require versus another state. So I ask for a yes vote and stand in strong support. Thank you.
Is there any further discussion on Senate Bill 197? Seeing none, all in favor of Senate Bill 197, please signify by saying aye. Aye. Opposed? The ayes have it. Senate Bill 197 is adopted. Mr. Kohler, please read the title of House Bill 1286.
House Bill 1286, Representatives Kagan and Salazar, concerning the court's authority to require prosecution in cases of police misconduct when the decision not to prosecute was an abuse of discretion.
Mr. Chair, I move House Bill 1286. There is no committee report.
Representative Kagan, to the bill.
Mr. Chair, the House Bill 1286 merely makes a change in the language from one standard to a slightly different standard in motions under 165209. Changes it from the arbitrary or capricious and without reasonable excuse standard to the abuse of discretion standard, and I ask for an aye vote.
Is there any further discussion on House Bill 1286? Representative Dorr.
Morning, Daniel. How are you? Thank you, Mr. Chair. Members, we heard this bill in a fairly long evening of committee, and while I know the intention is a greater intention of making sure that when situations, and tragic in many cases situations happen, but with our police departments, when investigations happen, they're done right. And lowering the standard is what this would do. And that standard, is there for a reason. And the reason is when you look at a case or a potential case, the DA's office has to make the objective decision on, is there a possibility of having this go further and come to a level of successful prosecution? And is there enough there? And the evidence is part of the investigation. A lot more goes on than we hear about in the general public, and they have to come up with, can they do that? And the standard has been, and for as long as I know of, has been clear and convincing. And changing it and lowering it, while there's debate around it, it makes it to where you could be sending cases forward, which the probability of success on the case would be low to start off with, but letting them go forward and setting it up for potential failure because the evidence is not there. And we heard testimony about that in committee. We also heard testimony from the district attorneys reminding us the district attorneys are not the police departments, and their job is not to cover for police departments, and they are actually offended at the idea that we think that's what they do. In fact, they look at the cases, they come to a position where they feel that if they have a legitimate reason with evidence to support, they absolutely will go after a wrongdoer, even if that wrongdoer wears a badge. And so I would ask for a no vote on this, as I believe what the intent is what it is, and the intent is an intent which I think we can agree on. The reality of what we're dealing with regards to police, with regards to the prosecution teams that are put to investigate any of the potential misconducts, has to be at a standard that makes sense and is credible for those taxpayers that end up funding it.
Representative Salazar.
Thank you, Mr. Chair. And with respect to my colleague, Representative Dorr, this bill is not aberrant. It wasn't just formed out of the air. We have problems with prosecutors bringing cases, legitimate cases against police departments. Since 1987, the Denver Post reported recently, since 1987, prosecutors have only brought 2 indictments against police officers out of the dozens of shootings that have occurred, out of all of the excessive force cases that we have seen on TV. only 2. What this bill does is it changes the calculus a little bit. Not a whole lot, just a little bit. The standard of clear and convincing that we are changing has been around only since 2011. And what we are saying is that there is one standard in this, which is abuse of discretion. That is a high standard already. Because there is concern about the behavior of prosecutors when it comes to police shootings, excessive force leading to serious bodily injury. That's why this bill is needed, and I ask for an aye vote.
Representative Dorr.
Thank you, Mr. Chair. And Representative Salazar, and we had a lot of this discussion in committee, and we won't go through the hour and plus that we did there again, obviously. My concern is, and you bring up the statistics, and I believe you said a Denver Post article, and is that a statewide statistic or just for the Denver, statewide? The issue I have is that while that standard, if we lower it here, we're still having a standard, because the DA's office has to look at the probability of success on a case. And when you have a lower standard to get into the courts with the filing, that standard is going to be up again from the court perspective, from my understanding of reading the legislation. And so I don't know, I mean, I also don't want to give the sense, and this would be more of a public, the sense of, oh, well, since the DA's filed something, there must be something really good here, because the standard is going to go back to the courts and go back to the clear and convincing, from what I understand, because we are not changing the courts looking at the case differently. We're just changing opening the door to get into the courts for the filing, if I understand this correctly.
Representative Kagan.
Thank you, Mr. Chair. Members, when a police shooting takes place, it is different to any other act that is potentially prosecutable. There are unusual pressures on prosecutors that are not present in other cases. There are pressures from certain sectors of the community to prosecute, prosecute, prosecute. And those pressures must be resisted, of course, by prosecutors, and are. There are some pressures in police shootings. Don't you prosecute. Stand with our police. Stand by our police. And those pressures must be resisted, and they are. But it is an acknowledgement of the special situation that arises in a police shooting. It is an acknowledgement of the special pressures that arise in those cases that we have so many good procedures in place. For example, the critical incident team, the response team to a police shooting, includes, in most jurisdictions, police officers and prosecutors from outside the jurisdiction to involve themselves in the investigation. That is an acknowledgement of the special pressures on prosecutors and on police when investigating a police shooting. Prosecutors issue letters of explanation across the state, explaining why they chose to not prosecute a police shooting. Why do they give those letters in those cases, but not in your average run-of-the-mill shooting? Because it is an acknowledgement that there is a potential for a breakdown in public trust in the prosecutorial exercise of discretion. And that's why prosecutors send out those letters. And it is good that they do. We have excellent prosecutors throughout our state, and they make these decisions correctly. There is also a provision in law which, for any case, allows the citizenry to go to the court and say, the prosecutor didn't prosecute this crime. It could be shoplifting, it could be rape, it could be murder, it could be trivial, it could be serious. The prosecutor did not prosecute this crime, judge, and I want you, judge, as a citizen, to review that decision not to file and tell us whether, in your opinion, it was arbitrary or capricious and without reasonable excuse. What this bill does is it enables that same process to go forward, but in a police shooting situation, it says, Judge, we don't want you to ask whether it's arbitrary or reasonable and without reasonable excuse. We want you to answer whether, in your view, Judge, it was an abuse of prosecutorial discretion. That is a more appropriate standard, I submit to you, members. Why is it a more appropriate standard? The abuse of discretion standard is used throughout our legal system. Every decision within the discretion of a trial court, whether to allow cameras, whether to allow someone to testify, whether to allow something into evidence, these decisions are made and are reviewable for an abuse of discretion. Every time the governor makes an appointment to a commission, it is within the governor's discretion, but it is reviewable by the courts for an abuse of that discretion. What does abuse of discretion look at? Abuse of discretion looks at whether or not improper influences were brought to bear and considered, whether improper considerations were taken into account in the exercise of that discretion. And that is precisely what the public wants and needs to know. Prosecutors need to be able to demonstrate when a police shooting takes place, because the pressures are extraordinary to prosecute and to not prosecute. Those pressures are extraordinary, and our prosecutors do not consider those extraordinary pressures. They make the decisions on whether there is a reasonable probability of successful prosecution. That is the standard they use. They look at the facts, they look at the law, and they marry the facts to the law, and they decide whether or not to prosecute. They do not yield to those pressures, but it is right that we are allowed to ask a judge to just pass an opinion on whether they have yielded to those pressures, whether it be the decision to prosecute or not. That question should be asked. And the question that is asked under current law, was it arbitrary or capricious and without reasonable excuse? In other words, did you look closely enough did you take this case seriously enough? Did you take this case seriously enough? I was assaulted, Judge, and the prosecutor didn't think it was serious enough to give it. It was just arbitrary, it was capricious. There was no reasonable excuse for not filing this charge. That's an appropriate question in a simple assault. But in a police shooting case, the real relevant question was, were you subject and were you overcome by the unreasonable pressure from the community that may have said prosecute, prosecute, or from the defenders of the police who say stand with police? Were those pressures brought to bear? And whether those pressures were brought to bear are not a matter of arbitrariness or capriciousness or lack of reasonable excuse. Those pressures, whether they were brought to bear and bore consideration of the decision, are a matter of abuse of discretion. The public trust will be served if the question is asked. The question is asked now, but it isn't quite the right question. This bill puts the right question into law. Was discretion abused in the decision because of the unusual pressures that are brought to bear in a police shooting case? I ask for an aye vote.
Representative Carver.
Thank you, Mr. Chair. Unfortunately, while the bill was being heard in judiciary, I had a family emergency and therefore wasn't able to hear the testimony firsthand and engage in the robust discussion we many times have in judiciary. However, I had an opportunity to listen to the audio later, and therefore must rise in opposition to this bill. First of all, let me say I very much agree with Representative Kagan and Representative Salazar that when you have a situation involving a police shooting, that the passions rise very quickly on both sides, and it does tend to become politicized. But respectfully, I think changing the standard from arbitrary and capricious, which focuses on what is the evidence versus the elements, and is there sufficient evidence to go forward with prosecution? That's what the current standard is in the law. Moving from that standard to an abuse of discretion, where the focus is which group in the community is lobbying the hardest and the loudest in pushing for or against prosecution, I think makes the process more politicized, not less, respectfully. And therefore, I think that perhaps the answer to some of the concerns we have with police officer shootings and ensuring that a full investigation is done, that prosecutions are brought in meritorious cases, and that justice is done for the victim of the shooting, that a focus on the evidence and whether it was arbitrary and capricious is still the appropriate standard, and perhaps what we need is more participation in using the filing with the judge in these cases where we believe the DA's office has not come to the right conclusion, respectfully. So I will be against the bill. Thank you.
Representative McCann.
Thank you, Mr. Chair, and I speak in support of this bill. There are several things about it that I like and reasons that I support it. Primarily, I guess the main reason is that the judge is an objective, trained legal mind, really not subject to political pressure. Thank goodness in our state we don't have election of judges and we have appointment of judges. So in my mind, if you have that kind of decision maker hearing the arguments that can be made on both sides, that is precisely the kind of situation that we want an objective judge to address. It reminds me of the bill that I did with Representative Nickel regarding the direct file against a juvenile. And the main reason that we did that bill was because we wanted to have that objective judge say, should a juvenile be filed on in adult court versus juvenile court, because it is such a critically important decision. So this bill, that's one thing that I really like, is that you put an objective person who will hear both sides in a court of law making the decision. Secondly, it also gives an individual or people in the community that opportunity to say to a judge, look, we have looked at what we know about this case, and we really think there was a mistake here and there was an abuse of discretion. So it gives the community some voice in these really, really critically difficult decisions. One of the things that we continually hear these days in light of all of the discussion about use of excessive force is that the community doesn't have a voice. And so at least this gives the community the opportunity to say, we'd like to have a judge make this decision, or at least review the decision that the prosecutor made. So that's the second reason that I think it's a good, well-drafted bill. The third thing is the issue of transparency, because that's another thing that we hear continually, is that the community doesn't understand or feel that they understand why a decision was made by a prosecutor in these cases. So this bill will allow, again, some transparency, because both sides will have the opportunity to present what they think, what their position is in open court. The next reason that I like it is that I think it gives the prosecutor a chance to be more public about their decision-making process. So the prosecutor is given the opportunity, again, within the structure of a court system which has guardrails and checks and balances, the prosecutor can explain in full detail the reasoning behind his or her thinking. So it gives the prosecutor more of a forum, an appropriate forum, to explain why they made the decision they made. And the last reason is that the abuse of discretion threshold is a tough one. This is not an easy, preponderance of the evidence. It's not even beyond the reasonable doubt threshold. It's an abuse of discretion. That's a pretty high burden. So it is still requiring that a high burden be met before a decision would be made to appoint a special prosecutor. So I think for these reasons, this bill is a really good bill. We've heard over and over about the community's frustration with the whole process in excessive use of force. And this bill really provides a number of safeguards and a number of reasons that it will provide an opportunity for both sides to be more transparent and to be more articulate about their reasoning. So I would really urge a yes vote on this bill, and I congratulate Representatives Kagan and Salazar for coming up with a reasonable and well thought out way to address this very, very serious issue of how we handle excessive use allegations against the police department. So I would urge a yes vote. Thank you.
Is there any further discussion on House Bill 1286? Representative Lawrence.
Thank you, Mr. Chair, and thank you for a really good discussion on this bill. We spent a fair amount of time in Judiciary talking about this, and I think a lot of the issues that we had with the bill have been raised, that we're setting a different standard, a lower standard here than is currently on the books. Right now, citizens have the ability to go to a court and ask for clarification. They can bring the issue up on any type of crime that's committed if they think there has been an abuse of discretion or an arbitrary or capricious decision was made. But I think one of the things that we're missing right now in this discussion that was brought up during the hearing was that DAs, when they're brought cases where they perceive a conflict of interest, maybe investigating a police department or sheriff's department in their district, they will refer that to another judicial district. In many cases, they don't do the investigation of people within their own district. So having that referred to a different judicial district adds another level of transparency and actually takes that out of the realm of undue influence. And I think we need to remember that as we're discussing this bill. I am concerned that we're lowering the standard to get this into court, but if it should go to court, you still have the same standard of evidence that you would have with any other case. And I'm not disputing that there are bad apples in any industry, in any profession. But I think taking a blanket policy and applying it across without recognizing that there are individual cases, individual decisions, and we don't always know what those are at the time, but maybe what we need is just a little bit more transparency in the process. And I don't think this really adds that. I think this actually gives another level of confusion and conflict to the public as they see, oh, well, it's a lower standard, we got them into court, and then they were acquitted. Well, that doesn't seem right. I still have issues with this policy. I think it could be worked on and come to a better balance of a process, and I don't think this bill has it right now, so I would ask for a no vote.
Representative Salazar.
Thank you, Mr. Chair. And Representative Lawrence and Representative Carver, I appreciate your words. I don't think you quite understand the impossible standard that is placed right now in statute. You not only have to prove arbitrary and capricious and without reasonable excuse, but then you have to prove, oh doggone, I just lost the words, abuse of discretion. And then not only do you have to prove that, but you have to do it all by clear and convincing evidence. It's an impossible standard when each of those is a standard amongst itself. Arbitrary and capricious is its own standard. Abuse of discretion is its own standard. And having to prove it all by clear and convincing evidence is its own standard. If you recall, during the debate, I asked the bill drafter very directly, isn't that their own standards? And he said yes. And as he said, it's layered. It's tiered standards. You're not understanding these standards. It's an impossible task. And I'm happy to change the rest of the statute too if that was allowed within the bill title, but that's not what we're looking at. It's an impossible standard. That's why you don't see cases brought under this. The last one was the Chambers case. And that person was not successful because it's an impossible standard. This balances it out. This says that we're going to look at the standard for what it is, abuse of discretion, which is still a high standard. In the most egregious of cases, excessive force leading to death, excessive force leading to substantial bodily injury, serious bodily injury. It's the 2 minutes was strangled to death. In the Lopez case, which recently another jury awarded, a federal jury awarded over $2 million on, nothing was brought. Because it's an impossible standard. We are saying we're not going to make it impossible for people to be able to challenge why a prosecution wasn't brought. That's good governance. That's good transparency. That's allowing our court process to work to its fullest function. And no, not every single case is sent from one county to another one to be looked at. There are some district attorneys' offices that will want to look at things that take place within their own counties and make decisions on them. This changes the calculus and changes it in favor of community. The community still has a tough standard to meet with this bill, but not an impossible standard with the way things are written now. And I ask for an aye vote.
Representative Lawrence.
Thank you, Mr. Chair. And Representative Salazar, thank you for those words. And I think you brought up a very legitimate issue, that if those standards are impossible to meet, why do we have them in place for every other case that's brought? Maybe we need to realign the standards across the board. Well, then why don't we do that instead of singling out law enforcement for excessive use of force? Again, if we have a problem, and the cases you cited were certainly issues that brought the public to their feet, and that's what I just heard, they are impossible, then we as a body need to address those standards so that they're applied equally across the board, whether it's a case of excess force by police, whether it's the case of a first-degree murder charge not being brought, whether it's the case of a sexual assault charge not being brought. No matter what it is, the public should have access to that so that they can address their concerns and have the court take an impartial look at it. I don't think this bill does that. This sets up two separate standards. And again, I would ask for a no vote.
Representative Kagan.
Thank you, Mr. Chair. I just want to clarify a couple of things. This is not a lower standard or a higher standard. It's a different standard. It doesn't ask harder questions or easier questions. It asks different questions. What the arbitrary or capricious and without reasonable excuse standard asks is, did you not file this case because you couldn't be bothered? It was just an arbitrary, capricious, and you have no excuse for not filing this case. You just didn't bother to file the case. That's not the fear in a police shooting case or in a highly politicized case. The question in a highly politicized case is, did you yield to improper influences? That question, in legal terms, is, did you abuse your discretion? Not, was it arbitrary, capricious, without reasonable excuse, but was it the result of improper influence? And in your average common or garden case where there is no prosecution brought, the proper question is, did you just arbitrarily, capriciously, and for no reasonable excuse, just not prosecute? The focus of that tends to be a little more towards, did you just not bother? No one thinks a failure to prosecute in a police shooting is because the prosecutor couldn't be bothered. The question in a police shooting case or any highly politicized case is, did you yield to improper influences? And the way we pose that question in legal terms is, was there an abuse of discretion? The abuse of discretion standard is neither higher nor lower.
Excuse me, Representative Kagan. Members, could we try to keep our side conversations at a little lower volume and pay due attention to the speaker at the well? Thank you.
The abuse of discretion standard is neither higher nor lower than the arbitrary or capricious and without reasonable excuse standard. It is different, and it is more appropriate in a politicized case than the other standard. And that, Representative Lawrence, is why I believe, in distinction to my learned colleague, Representative Salazar, that it is right to have different standards in these different cases because different facets come into play in a police shooting case than come into play when a prosecutor has failed to prosecute a simple assault outside a bar. Different questions arise. It is not so much, could you not be bothered? Did you not take it seriously? It is, did you yield to improper influences? There are different types of cases. They require a different standard, neither higher nor lower, but different. This standard is more appropriate, and that's why I urge an aye vote on this standard, this abuse of discretion standard.
Is there any further discussion on House Bill 1286? Seeing none, the question before us is the adoption of House Bill 1286. All in favor, please signify by saying aye. Aye! All opposed? No! The ayes have it. House Bill 1286 is adopted. Mr. Kohler, please, Mr. Assistant Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1288 till Monday, April 13th.
Seeing no objection, House Bill 1288 will be laid over at the request of the Assistant Majority Leader. Mr. Kohler, please read the title of House Bill 1291.
House Bill 1291 by Representative Melton concerning prohibiting the use of a chokehold by a peace officer.
Representative Melton.
Thank you, Mr. Chair. I move House Bill 1291 and the Judiciary Committee report.
To the Judiciary Committee report.
Thank you, Mr. Chair. In Judiciary, we made a couple of amendments. One, we made sure to insert intentionally. We also made sure to align the language more so with that of lethal force. And lastly, we actually had to make this against a person to make sure that that was clear. And so with that, I ask for an aye vote.
Is there any further discussion on the Judiciary Committee report? Seeing none, the Representative Van Winkle.
Thank you, Mr. Chair. This is to the amendment. I do support the amendment. It seems like a very good idea. First, it does two main things, and Representative Melton already covered it, but to go into a little bit more depth, if a police officer is in a tussle with someone or trying to restrain someone, and they accidentally go from trying to restrain someone to thus choking them, charges won't be brought. And then secondly, if the officer feels like his life is in danger, or anyone in the vicinity's lives are in danger, and he must use a chokehold, he has no other choice, then I do believe charges won't be brought for that either. So I do believe that's the amendment, if I'm correct, and I think it's a great amendment, good amendment. Vote yes on this.
Is there any further discussion on the amendment in the Judiciary Committee report? Seeing none, all in favor of the Judiciary Committee amendment, please signify by saying aye.
Aye.
Opposed? The ayes have it. The amendment is adopted. Representative Melton to the bill.
Thank you, Mr. Chair. Members, House Bill 1291 does two things. It defines what a chokehold is. There are two main types of chokeholds, one that cuts off airflow, which is also known as a tracheal hold, and one that cuts off blood flow, which is also known as a carotid or a sleeper hold. With both of these, there are risks that if it's not done properly, that the victim could end up suffering long-term serious bodily injury and or death. We've seen this in national news, but more importantly, we've seen this in Colorado in 2010 when Marvin Booker died in a Denver jail from being held in a chokehold for 2.5 minutes. Members, we want to prevent that from happening again. And so the goal of this bill is, one, to protect the public from these dangerous practices, and two, to restore confidence with the community, that they know that police officers will not be using this in an arbitrary fashion or in a dangerous practice. The language that we've amended into the bill, I do agree with. It is in alignment with what some other states have done with very similar legislation. Again, members, let's make sure that we are rebuilding trust with the community and law enforcement by voting for House Bill 1291. I ask for an aye vote.
Representative Williams.
Thank you, Mr. Chair. And members, I rise in support of House Bill 151291. This is a bill that is a part of the rebuilding trust between the community and law enforcement. We've seen a lot of situations across the country where chokeholds have been used inappropriately. We've seen our own instances here in the state of Colorado. And the whole rebuilding trust package rebuilds the confidence of those who our police protect. And I want to make sure that you understand, while the chokehold bill has been through the committee, we've gotten support. It has a strong stakeholding process, and Representative Melton has done an incredible job to make sure that it's only used in self-defense. And I would like to ask you for an aye vote on House Bill 1291.
Is there any further discussion on House Bill 1291? Representative Salazar.
Thank you very much, Mr. Chair. Just want to commend Representative Melton for bringing this bill. As we know, this is one of the most pivotal bills that we have that's necessary to bring here in the Colorado legislature that really addresses a very serious problem. And I'm just amazingly proud of you, man. Thank you very much. I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of House Bill 151291. All in favor, please signify by saying aye. Aye. Opposed, nay? The ayes have it. House Bill 151291 is adopted. Mr. Assistant Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1007 and Senate Bill 87 to Friday, April 17th.
Mr. Kohler, seeing no objection, the two bills will be laid over at the request of the Assistant Majority Leader. Mr. Kohler, please read the title of House Bill 151013.
House Bill 1013 by Representative Corum, also Senator Sonnenberg and Hodge, concerning the implementation recommendation number 1 set forth in a study of the South Platte River Alluvial Aquifer prepared by the Colorado Water Institute pursuant to House Bill 1278.
Representative Corum.
Thank you, Mr. Chair. I move House Bill 1013 and the Agriculture and Appropriations Committee reports.
Thank you, Representative Corum. To the Ag Committee report. Approps Committee report.
Thank you. I'm ready for that one. It just changes to 1516, does funding of $41,959 and strikes 1278 and substitute 1278 and in connection there with an appropriation.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. Those in favor say aye.
Aye.
Opposed? No. The committee report passes. Representative Corum to the Ag Committee report.
Members, this is a major change. It strikes the word if.
Is there any further discussion on the Ag Committee report? Seeing none, the question before us is the adoption of the Ag Committee report. All in favor say aye. Oppose? The ayes have it. The Ag Committee report is adopted. Representative Corum to the bill.
Thank you, members. This is a bill reacting to the 1278 Aquifer Study Report. Ask for a yes vote.
Is there any further discussion on House Bill 151013? Seeing none, the question before us is the adoption of House Bill 151013. All in favor say aye. Those opposed, no. The House Bill 151013 is adopted. Mr. Assistant Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1165 to Monday, April 13th, and House Bill 1194 to Monday, April 20th.
Is there any objection to laying over the bills as requested by the Assistant Majority Leader? Seeing none, the bills will be laid over. Mr. Corey, please read the title of House Bill 1229.
House Bill 1229, Representative McCann, also Senator Martinez Humana, concerning retaliation against the prosecutor.
Representative McCann.
Thank you, Mr. Chair. I move House Bill 1229 and the Appropriations Committee report, as well as the Judiciary Committee corrected report. There were two reports put in your bill folders. The first one was not accurate, so it's the corrected committee report, which is 002.
Representative McCann to Appropriations Committee report 002.
Thank you, Mr. Chair. So the Appropriations Committee report simply appropriated a small amount of funds for future use in the case of convictions. So I would ask for a yes vote on the Appropriations Committee report.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the adoption of the Appropriations Committee report. Those in favor say aye.
Aye.
Those opposed? The Appropriations Committee report is adopted. To the Judiciary Committee report, Representative McCann.
Thank you, Mr. Chair. Again, this is C002, the corrected Judiciary Committee report. The committee raised some issues regarding the inclusion of the term harassment. So that was taken out by the Judiciary Committee report. And there was also some language taken out regarding when the charge could be brought for any duty within the scope of a prosecutor's employment. So that was also removed from the bill by the Judiciary Committee report. So I would ask for a yes vote on the Judiciary Committee report.
Is there any further discussion on the Judiciary Committee report? Seeing none, the question before us is the adoption of the Judiciary Committee report. Those in favor say aye. Opposed, no. The Judiciary Committee report passes. Representative McCann to the bill.
Thank you, Mr. Chair. So this bill is a pretty simple bill. It simply establishes the crime of retaliation against a prosecutor and makes it comparable to a current crime that we have for retaliation against a judge. We also have retaliation against jurors currently in our statutes. And we also have a tampering with a witness or victim felony in our statutes. So this simply includes prosecutors in that array of people for whom retaliation can be charged as a felony. So I would ask for your yes vote.
Representative Lawrence.
Thank you, Mr. Chair. And members, we heard this in the Judiciary Committee, and as Representative McCann had mentioned, we went through what for Judiciary was not a robust discussion, but for any other committee would have been a robust discussion.
Representative Lawrence, hold on just a second. Members, could we have some order in the chamber? It's hard to hear Representative Lawrence's words of wisdom. Please proceed.
Thank you, Mr. Chair. Well, now I can regale you with my words of wisdom. Again, we heard this in Judiciary, and the changes that were made were very specific to some of the concerns that we had, especially the removal of the harassment language. I think we've seen over the course of this session that harassment has been applied in a lot of different ways and can be interpreted in many different ways. So with the changes that were made in Judiciary, I think this actually turns out to be a pretty good bill, recognizing that DAs have a very difficult job, and we heard from several who had to change their lifestyles, had to change the way they function every day. They could no longer take the same route to work every day. They had to change their patterns. They had to, when they shopped for a home, they had to be looking at how the windows were situated in the home because they had been threatened either by clients or by someone associated with a case that they had prosecuted. So it brought up a lot of issues that many of us had not really thought about or had not personally encountered, which was very informative to those of us sitting on the committee. So I think I would like to thank Representative McCann for bringing this. I've heard from both of the DAs in my district, and they certainly support this bill. And I would ask the members of this chamber to please support it.
Representative Pabon.
Thank you, Mr. Chair, and I rise in strong support of House Bill 1229. You know, I've heard Representative Lawrence and Representative McCann sort of talk about the dangerous job of being a prosecutor is, and in House District 4, one of my good friends and neighbors suffered from the ultimate tragic attack and murder in 2008, if you remember. Sean May, who was a Denver district assistant district attorney, was followed to his home and brutally murdered in his backyard. And so we still have the annual Sean May Memorial Scholarship and run to honor his memory. That case is still unsolved. And this happened just literally 2 blocks from my house. And so while we don't know whether or not it was in retaliation for his work as a prosecutor, there's probably good evidence to support that. And so if this can serve as a preventive measure to let those know that there is punishment and that this punishment fits the crime, then we should pass this bill. I rise in strong support.
Is there any further discussion? Representative Garnett.
Thank you, Mr. Chair, and I rise in strong support of 1229. I have 2 family members who are prosecutors, and I know that they put themselves in harm's way by taking on very difficult and dangerous cases. So anything we can do to reassure the community that there is a penalty for any retaliation against the community service that our prosecutors work on a daily basis is a good thing. And so I want to thank the sponsors for bringing this forward, and I would urge all members to support this bill.
Representative Van Winkle.
Thank you, Mr. Chair. I also rise in support of this bill, and I know there's been some concern raised that we're carving out something special for these prosecutors. And that might partially be true, but think about the setup of a courtroom. You have the judge, you have the jury, the defense, you have the prosecutor. The prosecutor is the one person in that room tasked with bringing charges against a criminal. they have the burden of proof for bringing the case, and that puts them in a unique circumstance in unique danger. So I rise in support of the bill. Thank you for it, Representative McCann.
Representative McCann.
Thank you, Mr. Chair. And I actually do have an amendment to this bill, which I would like to propose. So I would move L003 and ask that it be displayed. Oh.
Representative McCann, the Judiciary Committee report is already passed, so the motion for the amendment is out of order.
All right.
Is there any further discussion on the bill, House Bill 1229? Seeing none, the question before us is the adoption of House Bill 1229. Those in favor say aye. Aye. Opposed? The ayes have it. House Bill 1229 is adopted. Mr. Assistant Majority Leader.
Thank you, Mr. Chair. I move to lay over House Bill 1235 till Monday, April 13th.
Seeing no objection, House Bill 1235 will be laid over at the request of the Assistant Majority Leader. Mr. Corey, please read the title to Senate Bill 15183.
Senate Bill 183 by Senators Hodge and Sonnenberg, also Representatives Arndt and Becker J, concerning the quantification of the historical consumptive use of a water right.
Representative Becker.
Thank you, Mr. Chair. I move Senate Bill 183.
To the bill.
Thank you, Mr. Chair. Members, this is a water bill that's coming in front of you, and what it does basically is to talk about and decide how we quantify consumptive use in a change case. It also talks about that we can't go back to an already decreed consumptive use case and change that as well. I ask for an aye vote.
So do I.
Representative Arndt? No? Representative Corum?
Thank you, Mr. Chair. I felt that Representative Becker was blocking my way to the mic there. It seemed like that to me anyway. And, you know, I truly respect Representative Becker a great deal. I even respect him and love him when he's wrong. And he happens to be wrong on this bill. And the reason he's wrong on this bill is getting the cart before the horse. This bill is giving the Supreme Court an answer to a question that is coming before them. And I think that when we do this, I think it is absolutely wrong that we intervene in a case like this. So, you know, with all due respect, I would certainly oppose this bill. I know Representative Becker knows of my respect for him, but, you know, he's young and sometimes he does make mistakes.
Representative Mitch Bush.
Thank you, Mr. Chair, and with all due respect to my colleagues, I would urge a no vote on this bill. This bill, as Representative Corum just said, intervenes in a pending Supreme Court case. Not just any water case, but a very important pending Supreme Court case. But more importantly, it fundamentally changes prior appropriation. Under our prior appropriation doctrine that we've had since territorial days, a water right as a property right refers to a decreed beneficial use. This bill would change that by essentially giving certainty to some water rights holders, those who have used their water right for a non-decreed use, and taking away certainty from those who have played by the rules. Moreover, it has questionable and perhaps negative environmental impacts. We heard in committee testimony against this bill from Audubon, from Trout Unlimited, from Western Resource Associates, and essentially the problem there is that the environmental beneficial uses like in-stream flow, RISIDs, recreational in-channel diversions, which are rec uses, are junior rights and might not continue to have their status. Moreover, speaking of the cart before the horse, we're in the process of our ongoing Colorado water plan. That water plan is based on trust between different basins who may well have very different interests. So far, we've kept that trust. This bill favors one version of that over another, and therefore may be quite premature. Thank you.
Representative Kraft Tharp.
Thank you, Mr. Chair. So I always appreciate these invigorating discussions about water rights, and I have never come down on a water rights bill before because I really respect you all who are the experts. But in this case, I need to tell you that this bill, if it does not pass, will have direct impact on my cities of Arvada and Westminster and on their water rights. And this is probably their #1 priority. This is important for the water rights in both of my cities. So while I truly respect all of this philosophical arguments around water rights, let's talk about the impact of this. The unintended consequence here, the impact of this is going to directly impact our local communities. So please, I beg of you, vote yes on this.
Representative Coram, is that an indication of a desire to speak?
Thank you very much, Mr. Chairman. It absolutely does have an impact, and we don't object to the use of the water. What we object to is using water without the right to use the water, without changing the right. And that's the crux of this case that we're talking about. So we're not trying to take your water right away from you. We're trying to make sure that you follow the process. If you want to change a water right and ask for a use, you're entirely welcome to do that, and you should do that, and encouraged to do that. But to buy a water right and to use that water for a right that it is not committed to is absolutely in violation of the prior appropriations doctrine, and that's what we are trying to protect.
Representative Arndt.
Thank you, Mr. Chair. It's absolutely true that it's not right to use water for an undecreed or non-decreed purpose, and currently we have sanctions in place to handle those misuse of water. And this bill seeks to accurately quantify historic consumption. It's a good policy.
Representative Sane.
Thank you, Mr. Chair. Members, I urge a yes vote on this bill. This is an important bill. We've did kind of the same thing for farmers about 2 years ago, where if they had a water right, there was more certainty in that water right. And essentially, we're doing the same thing now for all water rights, including cities. It's not just for cities, but it includes cities. And there's a lot of times where a city doesn't need all the water that they have. They may actually lease it out to farmers, which benefits agriculture. And anytime there's more certainty in a water right, especially for some of our municipalities, there may be less buy and dry of farms. And I'm going to speak from the perspective of the city of Ault. The city of Thornton's manager, his ancestor is one of the ones that came out to Colorado from Governor Gilpin's silent call that you should come out to Colorado, the rains will fall, the plows, answer the prayer of labor, and if you simply farm and put your plow on the ground, all these artesian wells are going to spring up. Well, that didn't happen, folks. A lot of those folks went bankrupt and went back to the East Coast. He went back to Pennsylvania broke. And what happened was the city of Thornton bought a lot of shares of water and bought a lot of farm ground in Ault. And that ended up buying and drying a lot of those farm grounds, and they're still dealing with the impact of this. But why? Because the city of Thornton wanted security. And we can understand that. So if we can give more certainty to these water rights, we're actually going to save a lot of our agricultural heritage. So I'd urge a yes vote on this bill.
Representative Vigil.
Thank you, Mr. Chair. We heard this in committee, and you know, I rise in opposition to this. This bill, we heard from all the county commissioners on the Western Slope, from Grand Junction, from Steamboat, from all those counties down there saying, you don't need our water down there. Please don't do that. We heard from the Water River Association and saying, it's not good for us. We heard from the environmental groups saying, it's not beneficial for the environment as well. And so, but one of the biggest considerations I gave to this bill was for us, the legislature, to intervene in a pending Supreme Court case. And that really, to me, is the crux of my rub with this bill, is we should not be interfering with the Supreme Court before they make a decision and saying, we're the legislature, let's just not do this. Let's not let the court intervene. Let's just decide for the courts. And I don't think that's right for us. I think there's some constitutional problems with that, and I guess we'll know because as we go forward. But it pits the East Slope against the Front Range, and there's water plans out there that are being developed. Water plans may not go as smoothly. They've been meeting for years on round tables and other venues to make sure that we have a viable water right and, a viable water plan. And so I think this bill can be run at a different time. I think the timing is all wrong on this. And for the benefits, they may be there for some communities and not for others, and I don't think it brings certainty to everybody. For sure, people that have junior water rights are going to lose out on this. So with that, I ask for opposition on this bill.
Representative Brown.
Thank you, Mr. Chair. And let me just say that this is a very complicated issue, to say the least. And I sat in committee, and I listened, and I listened, and I tried to get my mind wrapped around this issue. And quite frankly, to begin with, like many of you, I thought, this makes sense. And then finally, the light bulb came on. I'm going to ask you to oppose this bill. For one thing, like's been said here before several times, is there's a Supreme Court ruling that we haven't had yet. We need to wait and see what happens there before we change laws in the middle of the stream. What this has to do with is consumptive use. And what has happened is there's been cities on the Front Range that have bought water, and what you buy is the consumptive use, the consumptive part of that water. You don't buy it all. Because if you buy water on the western slope, that water is used over and over and over again. So what you buy, if you buy farmer's water over there, somebody's water, you buy the consumptive part of that water. Now, what has happened is there's been some, the way I understand it anyway, there is some water that was in non-use that had been going down the stream for years, going across the state line in the Colorado drainage, and that is the water that has already been going there that we're talking about. This is water that has been consumed. This is the water that we're discussing here. The consumptive use of that water, yes, belongs to those who have bought that water. But this water that has been in non-use, that's been going down the stream, that is the water that we're talking about. And that is not to come over. That is not the consumptive use. That is not what is to be brought over to the Front Range. This is what's before the Supreme Court. This issue right now is to decide this. I don't think that we can decide this here in the legislature. I hope that I understand it right, and maybe we're going to find out that I don't. But that's the way I understand it. And so I would urge a no vote on this bill.
Representative Jay Becker.
Thank you, Mr. Chair. And members, nothing's harder than being on the opposite side of great representatives that we work with every day and sit here. But as we know, water is for fighting, obviously. Members, with this bill, I was hoping to come up, say, good bill, vote yes, and obviously we're beyond that point at this juncture. But what this bill does is give certainty and stability to water rights holders. It doesn't change what we do with undecreed use, is what we're talking about now. Undecreed use has always not been to the detriment or to the benefit in considering consumptive use for anybody. The state engineer still has the power to stop that as well, and that was testified inside of the Ag Committee, has the power to stop it and should stop any undecreed use. We understand that. We don't take that away. It still continues to allow the courts that if there are periods of non-use to either use it or not. That is their decision, as has always happened inside of here. So what we're doing is giving the stability to the water markets moving forward so that we don't have any of these buy and dry situations that we're talking about. And yes, we are saying that this is going through us before it goes through the Supreme Court, but it's not just that case, it's hundreds of other cases that are sitting inside of water court. We are giving them the answer as to how these things should be handled. But remember, we're just clarifying how undecreed use has always been handled. That's what we're doing. And as hard as it is to be on the opposite side of our good friends, I'd still ask for an aye vote.
Representative Corum.
Thank you, Mr. Chair. I will be very brief. I know there's people here that want to go to a Rockies game and people like me and J. Paul Brown that want to go home. But the fact is, we are intervening in a law case. Also, something we're doing that we're usually very careful not to do. We're pitting one part of the state to the detriment of another part of the state. Not one single Western Slope representative, not one single water company, not one single individual that I'm aware of has come forward in support of this. Let's let the court system work, and I'm totally satisfied with what the courts decide, but let's don't 65 amateurs become administrators of Colorado water law. Let's let the courts decide this issue.
Is there any further discussion on Senate Bill 183? Seeing none, the question before us is the adoption of Senate Bill 183. All in favor, say aye. Aye. Opposed? No! The ayes have it. Senate Bill 183 is adopted. Mr. Assistant Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
Is there any objection? Seeing none, the committee will rise and report.
The House will come back to order. Mr. Kohler, please read the report of the Committee of the Whole.
Madam Speaker, Committee of the Whole begs leave to reports under consideration of the following attached bills being second reading thereof and makes following recommendations thereon. House Bills 1013 amended, 1229 amended, 1286, 1291 amended, 1307 amended. Passed on second reading in order of gross, placed on the counter for third and final passage. Senate Bills 183 and 197 passed on second reading in order of revised and placed on the counter for third and final passage. House Bills 1165, 1235, 1288, and 137 laid over until April 13th, 2015, retaining their place on the calendar. House Bills 1007, Senate Bill 87 laid over until April 17th, retaining their place on the calendar. House Bill 1194 laid over until April 20th, retaining its place on the calendar.
Representative Lee. You've heard the motion that the House adopt the report of the Committee of the Whole. There are no amendments. Mr. Kohler, please open the machine and members proceed to vote. Representative Priola. Oh, there you are. Take your time. Close the machine. With 64 ayes, no noes, and 1 excuse, the report of the Committee of the Whole is adopted. Madam Majority Leader, should we? Yeah, let's introduce this. Mr. Kohler, please read the title of SJR 22.
Senate Joint Resolution 22 by Senator Newell, also Representative Lee, concerning recognition of October as Conflict Resolution Month in Colorado.
Madam Majority Leader.
Thank you, Madam Speaker. I move to suspend the rules for the immediate consideration of SJR 22.
The motion is to suspend the rules for immediate consideration of SJR 22. All those in favor say aye. Opposed, no. Motion passes. Representative Lee. Oh, Mr. Kohler, please read the title of SJR 22.
Senate Joint Resolution 22 by Senator Newell, also Representative Lee, concerning recognition of October as Conflict Resolution Month in Colorado.
Representative Lee.
Thank you, Madam Speaker. It is appropriate that we bring this resolution today after our marathon session on Wednesday, during which we adopted a balanced budget. I move Senate Joint Resolution 15022.
Please proceed, Representative. The motion is in order. Please proceed, Representative.
Members, you can be seated. We need not read it at length. It's fitting that we, the legislators representing the people, promote and encourage conflict resolution. It is done so by civility and compromise, modeled and led by our Joint Budget Committee members this week. Wednesday night, we did so by our actions, and today I ask that we do so by joining Governor Hickenlooper with this resolution recognizing October as Conflict Resolution Month in Colorado. Conflict is endemic in all that we do. We meet for hours every day on the floor and in committees. We confront each other at the core of our beliefs about issues of policy and sometimes of politics as we attempt to craft the best laws for the people of Colorado. Politics, it is said, is the art of compromise, moving from conflict to conversation to respectful resolution. We in this chamber pass 300 to 400 bills a year for the governor to sign, most on a bipartisan basis, many by votes with overwhelming majorities. We unanimously agree on scores of issues and resolutions. We do so, I suggest, because we know how to engage in conflict resolution. Last night, we modeled it. The night before, we modeled it for the citizens of Colorado. Today, by this resolution, we commend it to them. Conflict resolution is based on mutual respect, both for the other side and for their position. It is based on the shared goal to find common ground and common good. It is based on civility and the willingness to compromise. The alternatives to conflict resolution are chaos and despair. Nationally, the failure of conflict resolution is Ferguson. Internationally, consider Syria, Yemen, Israel, Palestine, and the Ukraine, and scores of others where compromise is a lost art and civility is an unknown virtue. By this resolution, we recognize the people whose lives are committed to conflict resolution, the mediators, the arbitrators, the collaborators, the restorative justice facilitators, the judges, and the magistrates, those who have helped others to find common ground, to promote understanding, and to preserve relationships, renew hope, and improve people's lives, whether in courtrooms, classrooms, boardrooms, or playrooms. I salute the peacemakers. I urge your aye vote on Resolution 1522. Thank you.
Is there further discussion on SJR 22? Seeing none, is there objection to taking a voice vote on SJR 22? Seeing none, all those in favor of SJR 22, please say aye. Those opposed, no. SJR 22 is adopted. Representative Lee.
Thank you. I move that the current roll call be added as co-sponsors.
The motion is to have the current roll call be listed as co-sponsors. Is there any objection? Seeing none, so ordered. The next order of business is consideration of conference committee reports. Mr. Kohler, please read the title of House Bill 1072.
House Bill 1072, Representative Fields, also Senator Newell, concerning harassment through an interactive electronic medium.
Representative Fields.
Madam Speaker, I move that the House adopt the first report of the first conference committee on House Bill 1072.
Please proceed.
Members, what we did in conference committee, we added 2 words, constitutionally protected, to the Senate amendment version. So I urge an aye vote.
Is there further discussion? Representative Quorum.
Thank you, Madam Speaker. I had the opportunity to serve on this conference committee. I think this is a great compromise, but I want to tell you the importance of this bill to me, because the morning that the Senate passed this bill, a friend of mine, daughter, committed suicide the night before because of cyberbullying.
Is there further discussion on House Bill 1072? The question is the adoption of the conference committee report on House Bill 1072. Seeing no further discussion, Mr. Kohler, please open the machine and members proceed to vote. Close the machine. With 58 ayes, 6 noes, and 1 excused, the conference committee report for House Bill 1072 is passed. Madam Majority Leader.
Thank you, Madam Speaker. I move for the repassage of House Bill 1072 as amended.
The question is the repassage of House Bill 1072 as amended. Seeing no discussion, Mr. Kohler, please open the machine and members proceed to vote. Close the machine. With 42 ayes, 22 noes, and 1 excused, House Bill 1072 is repassed as amended. Mr. Kohler, please read the title of House Bill 1204. Oh, yes, co-sponsors for House Bill 1072. Close the machine. Mr. Kohler, please read the title of House Bill 1204.
House Bill 1204 by Representative Pabon, also Senator Kerr, concerning the creation of a distillery pub license.
Representative Pabon.
Thank you, Madam Speaker. Madam Speaker and members, you can hear the cheers from outside the chamber as I move the adoption of the first report of the first conference committee on House Bill 1204.
Very appropriate that motion should happen today, Representative Pabon. Please proceed.
Thank you, members. And not only is it the thousands of people outside cheering for this adoption, but I want to thank Representative Lontine and Representative Tate for joining us on this conference committee, and they can regale you with the epic battle that we had with the Senate, because ultimately it was the Senate who tried to change this perfect bill, and we stood strong as the House, as we stand strong on all of these amendments, and we won. So we're basically acceding back to the original version of this bill and ask for an aye vote.
The question before us is the adoption of the Conference Committee report on House Bill 1204. Is there further discussion? Seeing none, Mr. Kohler, please open the machine and members proceed to vote. Close the machine. With 659 ayes, 5 noes, and 1 excused, House Bill 1204, the Conference Committee report for House Bill 1204 is passed. Madam Majority Leader.
Thank you, Madam Speaker. And despite this being a Representative Pabon bill, and in honor of the thousands of people that are watching online right now, and the thousands of people outside cheering on this bill, I move for the repassage of House Bill 1204 as amended.
The question is the repassage of House Bill 1204 as amended. Is there further discussion? Seeing none, Mr. Kohler, please open the machine and members proceed to vote. Close the machine. With 64 ayes and 1 excused, House Bill 1204 is repassed as amended. I believe we are in to announce. Oh, yes, co-sponsors. I keep forgetting you, all you co-sponsors who want to be on this bill. Close the machine. I think you got in there. So, announcements and introductions. Representative Danielson.
Thank you, Madam Speaker. And members, contrary to what Madam Majority Leader and Speaker Pro Tem Pabon mentioned, the cheering outside is for the Colorado School of Mines. Today is E-Days, and they have driven an ore cart all the way down Colfax from Golden, and they are having a good time out there. So I urge you to join me right after we're done here with our business today and come and visit with the bright and talented students from the Colorado School of Mines, which of course is in House District 24 that I represent. So thank you for taking a minute and visiting with them with me.
Representative Singer.
Thank you, Madam Speaker. And we have a special guest here from the 63rd House District in the state of Louisiana, Representative Dalton Monterey. Please join me in welcoming him to the state of Colorado. Thank you.
Welcome. Representative Kraft-Tharp.
Thank you, Madam Speaker. So, members, if we could all say welcome to Lucas Elementary from Westminster, Colorado. They were sitting right up there while we were transitioning, and I know that they will realize it if we all wave and say, hello, Lucas Elementary. Thank you.
Representative Court.
Thank you, Madam Speaker. Finance Committee, since we lucked out so much this week by not having any meetings, next week is going to be piled up. So look at your calendar closely and add House Bill 1346, the tax havens bill from Representative Foote and Pedersen, to the Wednesday calendar. That means we have 8 bills on Wednesday. And upon adjournment, we'll have 5 bills. So we'll be working through some meals. So let's all get prepared. Thank you.
Representative Rosenthal.
Thank you, Madam Speaker. And we also have a school group from Mia Clements Homeschool. There are apparently 10 folks up in the gallery. And why don't you stand for us, and we'll acknowledge that you're here and all the good work that you're doing. Thank you.
Representative Kagan.
Thank you. Members of the House Judiciary Committee, first, thank you for your patience yesterday. It was a very long hearing, and I appreciate how patient you all were. The bad news is that Tuesday is going to be just as bad. Thursday is going to be just as bad. And there is an addition to Tuesday's calendar. In the on adjournment committee on Tuesday, we are adding as the first item House Bill 1303 by Representative Melton, sentencing for second-degree assaults, action only. That is an addition to Tuesday morning's calendar.
Representative McCann.
Members of the Health, Insurance, and Environment Committee, you are lucky compared to the Judiciary Committee. We are going to be moving Representative Young's bill that's set on Tuesday on adjournment to our Thursday calendar. So we will not be meeting Tuesday on adjournment. We'll just be meeting on Thursday.
Representative Ryden.
Thank you, Madam Speaker, members of the State Veterans and Military Affairs Committee, and all those listening in and listening over in the lobby. If you want to know Monday's bills, the order will be in your calendar, but advance notice here. The first bill up will be Senate Bill 86, Representative Joshi. Second bill up will be House Bill 1168, Representative Neville. The third bill will be Senate Bill 175 with Representative Humphrey. The fourth bill will be House Bill 1138 with Representative Ransom, and the fifth bill will be Senate Bill 32 with Representative Ransom, and the sixth bill will be House Bill 1152 with Representatives Nordberg and Van Winkle. We will be meeting in room 271. That's room 271. Thank you.
Are there further announcements and introductions? Seeing none, Madam Majority Leader.
Thank you, Madam Speaker. I move that the House stand in recess until noon.
The motion is for the House to stand in recess until noon. Have a nice weekend, everybody, and go Rockies. We are in recess.